Ms. Graham.
Thank you. Before lunch, we were looking at your letter of instruction, the 2nd of September 2015. That was COPFS 02557. I wonder if we can have that back on the screen and continue with page 4. Sorry, it was COPFS 02557. There we are. And page 4, please. We were talking about the bullet point that related to race. There we are. And do we see that the 3 specific examples, we mentioned those just before the break, and we looked at the detail of those, but does it appear that they have all come from discussion with the family? So whether there was any evidence that any of the officers had expressed racist views, the family had inquired about officers in Fife engaging in racist texts and wondering if they'd had any contact with the attending officers, and then it was the family that had asked that in relation to any history of racism and specifically about the conduct of PCL and Peyton. So the points mentioned are actually points that the family had specifically raised.
Yes.
With the Crown.
Yes.
So does that mean that in fact the Crown did not come forward in this letter or in other correspondence with other possible lines of active investigation? That the only lines here suggested appear to come from the family?
Yes. The terms of the instruction, I think with hindsight, were intended to be general, as I said in my evidence this morning, require confirmation, etc., generally race and racial motivation, and then highlighting 3 specific concerns that had indeed been highlighted by the family.
Right. We've heard some evidence from PERC witnesses who said they thought it was difficult to investigate motivation. What's in someone's mind.
Yes.
And that they sought guidance or assistance from the Crown in relation to that. Their impression, as they explained it to us, and it'll be a matter for the chair, was that they did not receive guidance from the Crown. And then they raised it again. And then really it was recognised that it was difficult, but they didn't really receive the guidance they were looking for. Do you have any comment in relation to that? Do you remember being asked for assistance?
I don't remember being asked for assistance, and in my preparation for the statement and for giving evidence, I haven't come across any request for assistance at any time during my involvement in the case. It is the case that there were meetings. There was and you may be coming on to that, some discussion where there was mention of the terrorist threat. But I don't recollect any request for guidance. If there had been, I suspect I would have recollected that. Nor do I remember any approach to anybody else at the Crown, to indicate, we're struggling with this, or we don't feel that we can do that. But having said that, we've been through the terms and the instruction, and I accepted this morning that with hindsight, there could have been more specific direction and a more collaborative approach, perhaps with input from others. But I don't recollect any request for assistance at all.
Given what the evidence you gave yesterday about the, can I say, limited experience of race investigations, and some members of your team no experience of race investigation.
Yes.
Do you take the view that your team and yourself were well equipped to give that guidance and assistance to PERC had they raised it maybe more formally with you?
I don't know if I would have been best placed to do that, I certainly wouldn't suggest that I would set myself up as an expert or somebody who would do that. I think that in relation to this inquiry as a whole, as I've indicated, there was some there was relatively little experience of this kind of investigation, and I think it is the case that, with the benefit of hindsight, that there could have been input externally in respect of how to go about this, rather than looking to the Crown all the time, and looking to individuals. That's probably the best way that I can answer that.
We did discuss with Kate Frame about whether she'd considered the possibility of looking externally to third parties. And she, and again I'm summarising her evidence, but she'd said they would have quite liked to have been invited to a meeting with Deborah Coles, the Director of Inquest, for whatever assistance that may have proved to be. But that was not something that PERC were invited to. Do you remember any issue about, or any decision taken not to invite PERC or not to include PERC in that discussion?
No, not at all. In fact, as I recollect it, the invitation to meet with Deborah Coles came to the Crown. So it was an invitation. I think to the Lord Advocate originally, but to the Crown, and the Crown attended that. So that was the focus of the invitation. There was no suggestion of inviting PERC, and although I might be mistaken in respect of this, I think that was around about the time that Mr. Anwar had indicated that the family had lost confidence in PERC and that there had been a breakdown in the relationship with the PERC. So it wasn't as if the Crown were arranging that meeting and thought, will we invite the PERC or not invite the PERC? The invitation, as I recollect it, was extended to the Lord Advocate, and thereafter Lindsay Miller and I attended that. And to the best of my recollection, that was the only time that there was such a meeting. I think there was a suggestion of a further meeting later on that didn't take place. So I only recollect one meeting with Deborah Coles. But again, there had been mention of inquest and perhaps Deborah Coles in correspondence. And I don't know. I can't speak for Deborah Coles as to whether she would have been willing to provide input, but I certainly wasn't aware at any time of this being exclusively for the Crown.
Right. And it was something you were invited to rather than something you were organising?
Yes.
Can we move on to the final bullet point in the letter, please? The family once again raised the question of whether there was evidence of officers inappropriately conferring prior to the provision of statements to PERC. Please advise whether social media sites that may be linked to any officers involved have been considered for examination in this regard. And again, is this an indication that this matter hadn't been specifically addressed in the first PERC report? Social media?
Yes, I don't think it had been referred to, yes, and that had been raised, yes.
And then I understand that Constable Payton continues to refuse to provide his weight to investigators. I understand that investigators were approaching Police Scotland to request their assistance in obtaining this information. Please advise of the progress in relation to this. Was this in connection with your examination of the issue of restraint and what the officers had done?
Yes, it was, but there had, as I recollect, been specific requests by Mr. Anwar for the weights of the officers, and that there was some difficulty in the obtaining of that and the provision of that. Some progress was made during the course of the investigation, but it wasn't immediately forthcoming, and as I recollect it, it was a constant theme to request the weights at various points, and that wasn't immediately forthcoming.
Right. And was that a request made to Police Scotland or to the individual officers?
I'm thinking and trying to recollect. It was an approach through the PERC, obviously. As to how they went about it, I can't quite remember. I do think that there was an approach through Police Scotland, but I can't say whether that was exclusively through Police Scotland.
Right. It then goes on to say, you will be aware that the family of the deceased have expressed reservations regarding the expert pathologist who have been approached to provide an opinion. It may be that others will require to be approached in this regard, and this issue will require ongoing discussion. Now, just to recap, this is the letter of the 2nd of September. There's letters of instruction have gone to Karch and Payne James from PERC after the first report was received. Who was the expert pathologist that was being referred to here in relation to the family's reservations?
I have to say, in reading that, and I know that the dates are of significance here, my recollection in respect of this was that they were referring to reservations in respect of Karch and Payne James, and perhaps particularly Karch.
Right. So this would be about, this is something you were aware of by the 2nd of September when you wrote this letter?
Must have been, yes.
Had you discussed these reservations with PERC at any time prior to this? We know the letter of instruction to Karch was sent out on the 13th of August, and this is the 2nd of September, so you clearly knew about the reservations by then. Did you discuss it with PERC or take any steps in relation to this?
I don't recollect any discussions with PERC involving any of the Crown team at that time.
All right. You don't set out what the reservations were. Is that an indication that you'd already explained what they were, or just something else?
I think from the terms of it, of saying you will be aware, I think that PERC were already aware of the reservations probably through Mr. Anwar.
Thank you. And then it says, I appreciate that a considerable amount of work still requires to be undertaken in relation to this matter. However, you will no doubt agree that the investigation requires to be as thorough as possible, and that concerns expressed by the family of the deceased have to be addressed. The Lord Advocate has indicated that it is his intention to meet with the family again towards the end of October, so that's the following month, and accordingly an update on the progress of these inquiries will be required prior to that meeting.
Yes.
And so in terms of, as we were saying, this is the letter which you sent to PERC after the first PERC report had been received.
Yes.
Mr. Brown, before we leave this letter, I wonder if you can help me with something. Could we scroll back up to the first page of the letter, please? And if we look at the first two bullet points, in the first bullet point, you required PERC to prepare a detailed analysis covering the accounts given by all officers and civilian witnesses in relation to the restraint process from beginning to end. And then in the first sentence of the second bullet point, you said that that account must thereafter be analysed and commented on by an independent expert who's qualified to comment on restraint techniques that were employed. Now, in relation to the exercise in the first bullet point, it must at least have been a possibility that at least parts of some of the accounts were untrue, or for one reason or another unreliable. Now, how would you have in mind that PERC would take these difficulties into account in preparing such an account?
My Lord, the intention in respect of this and the request for an analysis was to, I think, to examine in detail what each witness had stated, and then to compare that with what other witnesses had stated, and that in particular that one should be looking at the police accounts and comparing them with, I suppose, the civilian accounts, and looking to see whether any inconsistencies could either be resolved or explained, or whether there was an obvious inconsistency that suggested the witness was mistaken, if I can put it like that, in respect of the account. And if I could perhaps, in thinking out loud, provide an example of that, going forward to the time that the Crown were carrying out their own investigations, there was an analysis of that type carried out by the Crown investigators, where there is, I think, reference to this in one of the documents, whereby each of the Crown investigators, the Crown team, summarised the accounts that were given by various witnesses, and after that exercise had been carried out, they compared it and were able to identify some clear inconsistencies. For instance, in relation to one witness in particular, who had described the number of officers that were involved at that point, it became clear from that analysis, to my recollection, that must have been mistaken, because that number of officers weren't present at that point. So it's that kind of analysis that I think was envisaged in respect of this.
I can see that an exercise of that kind would identify an inconsistency in a particular situation, but it's the concept of getting together an account out of an exercise of this kind, positively to examine. Now, I'm wondering whether, particularly in a situation of the kind that occurred here, you'd be likely to end up with a number of scenarios depending on what package of evidence you accepted. Do you follow?
Yes, you could. I entirely accept that the conclusion of that exercise would be uncertain, and it might be that you did have accounts that were not consistent. But I think the view of everybody that looked at this letter and approved it, and in relation to myself, was that there was a value in conducting that type of analysis to ascertain whether any of the accounts could be discounted as unreliable, and get as clear a picture as possible in order to move the investigation forward. It was that type of analysis that...
If you move on to the second leg of the exercise, the second bullet point, you then have the problem of what account you're asking your expert to comment on. Do you follow that?
I do, exactly, my lord. It would perhaps, and I don't think the expectation would be that it would produce a single account, but it would, in my view, be a valuable exercise, because it would provide as much clarity as possible in relation to the factual account, and thereafter to present that.
It might be that, following on from the first exercise, you would have to ask the expert to comment on a number of possible scenarios.
Yes, you might, and in addition to that, you might be left in a situation whereby you simply had to provide the expert with the accounts given by the various witnesses, and to ask, as you put it, for a comment in respect of the salient aspects. Now, yes.
If you do that, if you just give the expert the accounts given by the various witnesses, what's the expert to make of that?
Well, the expert, I think, from my perspective, the expert could comment in relation to, well, if that scenario was the situation, then my opinion would be this. And if the other scenario was correct, my opinion either would be altered or wouldn't be altered in respect of it.
Now, in relation to the first bullet point, did PERC prepare such an analysis?
They didn't prepare, to my recollection, they didn't prepare an analysis that was sufficient for the purposes for which it was intended. Hence, that the Crown carried out that type of analysis during its phase.
So I take it that PERC didn't produce the kind of analysis that you expected, nor did they carry out bullet point 2, namely to get an expert to comment on it.
I think the short answer to that is that there wasn't, no. There were some experts who commented on the restraint process, but in respect of the analysis and an expert who had been approached for the specific purpose of commenting on whether the approach was in accordance with the standard operating procedures and the training and the like, that wasn't present in the later PERT report, to my recollection, my Lord.
Thank you.
Thank you very much. I'm going to move on from this letter and move on to the next, in terms of the chronology. That was the 2nd of September, and on the 10th of September there is a report received from Dr. Karch in response to the particular letter that we looked at before lunch.
Yes.
Can we look at his report, PERC 02526A, and this is from the 10th of September. So 2526A. And we've heard evidence about this before in relation. This is a report from Stephen Karch sent to Kate Frame, the Commissioner, on the 10th of September, and we've heard evidence from Ms. Frame in relation to this.
Yes.
And I wonder if we can look, please, at, well, I should say it's a response from Dr. Karch, and it says, in your letter of August 13th of this year, you posed 4 questions, and that's a reference to the letter of instruction we looked at before lunch. And then if we can look at page 3, please, or let's start with page 2. The way he does it is he sets out question 1, he repeats the question, and then he gives a brief answer and then an explanation for each. That's the format that he follows throughout the report. And the first question relates to the physiologic effect of the drugs detected in the toxicology sample, either individually or in combination on the deceased and in the circumstances of his arrest. And he responds in an answer there. Can we look at the page 3 towards the end of paragraph B? And he's talking here about MDA, MDMA and alpha PVP. And he talks about Mr. Bio, the decedent, exhibited many of the features of excited delirium.
Yes.
And he says the clinical practice 10 to 13 symptoms are generally recognised as components of the excited or agitated delirium, depending on who is drafting the list. And the list includes, and then he gives A to K, a series of factors or components, as he puts it in the letter, for excited delirium. When did you have an opportunity to read this report?
Yes.
And Mr. Dr. Karch is, can we just look up at the top of that section, please? Thank. No, sorry. If we come down towards the features, that's lovely. He talks there about if the increase in brain dopamine is too great, disruption of normal brain function may occur with lethal consequences, sometimes in the form of a disease known as excited delirium syndrome. And Mr. Bio exhibited many of the features of excited delirium. When you read in this report, obviously the instructions did not refer to excited delirium at all. There was no invitation to Dr. Karch to comment on excited delirium, but he has begun to talk about it in his report. And what he appears to be talking about is a disease known as excited delirium. Now, you'll recollect yesterday we spoke about the final post-mortem report, and Dr. Shearer and Dr. Buhadir had said it wasn't a disease, it wasn't something pathological, it was at best some sort of psychiatric matter, but not something that the forensic pathologists could comment on.
Yes.
But there was an awareness that this was a controversial area. When you read this, what did you think about it when it appeared in this report? Mention of excited
I
delirium and mention of it being a disease.
Yes, I think I was somewhat surprised to see it. That's looking back. Surprised to see it in the sense that, as you say, there hadn't been a specific direction to it, but by that stage, even mention of excited delirium, because of concerns that had been expressed by Mr. Anwar, was enough to make it jump out at me and I think others. So there was mention of it. We may be looking further down in the report, but seeing that in respect of this, when there had already been, or at least the start of representations to the Crown, that excited delirium, as I think I referred to it yesterday, was something to be treated with extreme caution. Here it was arising, so I did note that.
He says in clinical practice, 10 to 13 symptoms are generally recognised. He makes no reference to ICD-10 or DSM-5 or psychiatric classifications of disease. When you read this, did you understand that excited delirium was in fact a disease? Were you questioning the report you'd had from Dr. Shearer and Dr. Buhadir?
I wasn't questioning their report at that stage at all. That wasn't something that I think was done at any stage, to question their report, because as I said yesterday, I think it was always the intention of the Crown, and in fact they did, to return to those two original pathologists. But no, it did not cause me to think, well, this revises or discredits the examination that had been carried out. I
mean, Dr. Karch is not a psychiatrist of any description. You'll agree with that?
Apparently the inquiry has, I think, heard evidence about that.
And then on page 6, where he refers to question 3, again, he mentions the question, what is the physiological effect of restraint of the deceased in the circumstances of his arrest? And he says, given the details of the situation, the effect of physical restraint would have been de minimis. Now, given our discussion yesterday, is it fair to say, my understanding, that he is the only expert that the Crown obtained a report from that said the effect of physical restraint would have been de minimis?
Yes, and he stated it in those terms, which is perhaps surprising, but that's what's there.
So another surprise that he would be so forthright in that regard also.
Yes.
And then in relation to his explanation, you'll see that A, mechanical asphyxia. If we can go on to the next page, page 7, at the top, he's talking about mechanical asphyxia. We've heard about positional asphyxia, mechanical asphyxia. And he He said no clinically significant effects were observed. Indeed, the whole concept of restraint asphyxia, as applied in this case, has been refuted many times in the peer-reviewed literature. Did that come as a surprise to you as well?
I think the short answer to that is yes. I'm thinking of yes. It was expressed in very definite terms, and it was something that stuck out. Let's put it that way to me.
And then B, primary effects of prone positioning. He discusses this in some detail in the paragraph. Theories involving the hog tie, formerly known as maximal prone restraint positioning or hobble restraint as a cause of death, also called positional asphyxia, were first proposed late in '92. However, the results of the initial research were ultimately withdrawn in open court by the very author who first suggested the idea. A large body of literature suggests MPRP has very little clinical effect. It is surprising, given the lack of evidence, that anyone would suggest that it can. It is equally surprising that this outmoded idea remains in the vocabulary of modern forensic pathologists, given the complete lack of supporting evidence. What was your impression when you read that?
My impression when I read that was that this was it was bordering on the personalised. I thought it was openly criticising other unnamed experts or contemporaries, and it was adopting a particular view in general about obviously an issue about which there was another body of opinion with which he vehemently disagreed, as he put into this, it's termed a report, but it's a compendium of information and addressed back. But he was expressing a very definite view on something that might be considered a comment on a very broad area of medical expertise.
Thank you. Did this cause you to have any concerns about his impartiality?
I think it probably caused me to pause and to realise that careful consideration would require to be given to this in the round. As regards it, rather than impartiality as to what the basis for this particular view was. That's.
And then looking down at the bottom of the page, question 4 appears. There we are. What was the physiological effect of A, B and C on the deceased in combination in the circumstances of his arrest? And the answer is, I conclude factor C is irrelevant. Factor C, you may recall, was the restraint.
Yes.
Factor C is irrelevant as there is no proof that such a disease entity even exists. Factor B is similarly irrelevant as there is no evidence of toxicity present. That related to the sprays. When you read that the restraint was irrelevant as there was no proof that such a disease entity exists, so it's the combination of restraint is irrelevant, he said it's de minimis, which contradicts other evidence you have, but also the idea that this is some sort of disease entity. What were your views at that point?
Well, I think at that stage there were some concerns emerging from my own personal perspective. I can't speak for the rest of the team, but what was notable from my recollection was that he was at odds already with the original pathologists, and he was at odds as well, as I recollect, with the much. I was going to describe it. Yes, I would describe it as a much more extensive and perhaps detailed report that was ultimately obtained from Dr. Payne James. This was, if I term it an outlier, perhaps that's much of a generalisation, but it was definitely not consistent and was extremely inconsistent with the conclusions of the other pathologists. So that was the kind of considerations that I was having at that point.
Thank you. And we don't need to go to this, but Dr. Payne James's comment was in relation to excited delirium, at least. I do not consider that his condition as described at the time of police contact represented excited delirium syndrome.
Yes.
So in that regard, he was contrary also to Dr. Payne James. Can I ask you to consider a letter, PERC 04246. Now this is a letter dated the 12th of October 2015, and I think we may have touched, one of your answers may have touched on this at this time. So this is the CARTS report was the 10th of September, so it's just over a month after the CARTS report had been obtained. And it's from PERC, and we'll see at the bottom of the page it's from, I think, Kate Frame. It's a lengthy letter. There we are, from the Commissioner, and if we can go back to the top. There's a summary of the situation in relation to the death of Mr. Bio and the cause of death as given in the final post-mortem.
Yes. And
if we can move down. There's then talk about expert witnesses and mention of PERC presenting CVs of several experts to the Lord Advocate, and that Payne James and CARTS had been instructed to provide opinions. And then PERC providing the expert witness package with various information to the experts, and there's a confirmation of the questions that were asked of those experts that we looked at earlier.
Yes.
And in addition, at some point, there's also been additional queries sent regarding the handcuffs and the fractured rib.
Yes.
And if we can move down, it indicates that the draft reports of Payne James and CARTS have now been received, and it provides a summary of the conclusions. And it mentions Dr. Payne James's conclusion, and we see there the conclusion in relation to excited delirium that I just mentioned.
Yes.
I'd like to look at the comments on Dr. CARTS, please. Here we are. It says, consultant in cardiopathology and toxicology. Now, I should say that we've also heard from Kate Frame that that was her understanding at the time, but she was not aware at that time that Dr. CARTS was not a forensic pathologist and had never conducted any type of autopsy. And also she was not aware that he didn't have any formal toxicology qualifications. That's only something that became known to the inquiry subsequently. Dr. CARTS is considered to be one of the world's foremost experts in this field.
Yes.
And she talks about his answers to the questions that we've just looked at. But let's move on from that section, please. And here it says, additional expert opinion. The Lord Advocate informed Mr. Amar Anwar, solicitor acting for the family of the deceased, that he had instructed the PERC to obtain expert opinion from Dr. Payne James and Dr. CARTS. Mr. Anwar erroneously concluded that the PERC was seeking evidence of excited delirium syndrome to explain the cause of death. However, and as the Lord Advocate is aware, no such opinion on EDS was sought. And certainly we didn't see any actual instructions to either of the experts inviting them to comment on excited delirium in any way. I think that's fair to say. But was it the intention that these experts, were they selected for the purpose of obtaining their views on excited delirium?
No.
Mr. Anwar, on behalf of the family, was requested to provide details of additional experts whom he considered may add value to the investigation. Mr. Anwar had already sought expert opinion from Dr. Nat Carey, an eminent pathologist, as to the cause of death, and has agreed to share Dr. Carey's report with the PERC and the Lord Advocate. Dr. Carey was provided with a pack containing the same information shared with Dr. Payne James and Dr. Karch, and was given access to samples for examination. I'd like to ask you about this section. Obviously, Mr. Anwar erroneously concluded that excited delirium was opinions on that were being sought. The Crown position is that they were not being sought, but in any event, both Dr. Payne James and Dr. Karch did speak about excited delirium in their reports.
Yes.
At that time, you've told us that the family were being given exceptional levels of engagement and disclosure in relation to assisting them to obtain their own expert opinion. Can you explain what was happening at this time in relation to these discussions with Mr. Anwar? Because we've also heard that it is unusual for the family to be asked to contribute in any way to the instruction of experts during an investigation.
Just so that I'm clear what it is you're asking here, could I ask you?
Well, let's break that down, because that was a bit of a long question.
Sorry.
What was happening at this time with Mr. Anwar?
What was happening with Mr. Anwar, to the best of my recollection, was that Mr. Anwar was engaged in seeking opinion on behalf of the family, and that he was being provided with information that the Lord Advocate and others considered was appropriate to assist him in doing that. So it was from the point of view of assisting him to be engaged in the process at this time.
So the Crown had the two pathology, the post-mortem report from two pathologists, Shearer and Buhadir. Mr. Anwar had instructed Dr. Nat Carey, who's also a pathologist.
Yes.
And the Crown had instructed Dr. Karch and Dr. Payne James, but not with a view to obtaining opinions on excited delirium.
Yes, they had been asked to provide expert input
But
at that stage.
not specifically in relation to excited delirium.
No.
And if we can move down the page, please. So Mr. Anwar was invited to comment on further experts, and on the 16th of September he wrote to the PERC asking that the following three experts be considered for instruction: Professor Crane, another pathologist, Dr. Lipsage, a psychiatrist, and Professor Pounder, a second pathologist.
Yes.
Can you tell us, first of all, how common in your experience is it for the family to be asked to recommend experts in an investigation?
I don't think I've had experience of that. Having said that, because of the particular circumstances of this particular investigation involving, as it did, police officers and the requirements for independence and involvement of the family, I appreciated that that's why this was being done. But and the short answer to your question is, I had no previous experience of this happening.
Right. And do we see, in relation to this suggestion, that there's now the two pathologists who carried out the post-mortem, and Mr. Anwar's firm have instructed Nat Carey, a third pathologist, and now two further pathologists have their names put forward, Professor Crane and Professor Pounder.
Yes.
Was there a need for 5 pathologists to be involved in this investigation?
I think that's a difficult question to answer directly. It was that the number of experts, whatever their title, they were being asked to provide input to assist in, as I said yesterday, separating out the various elements of the cause of death. As I recollect it, Mr. Anwar accepted that that was a course of action that was appropriate. I hope I'm not misrepresenting that. I think there was correspondence that pointed out that was something that clearly was being undertaken, but he was clear that it had to involve consideration of the role of restraint and any other contributing factors. And as I say, I'm very confident that by this stage he had already made very clear concerns about any reference in any meaningful sense to excited delirium. It was the role in particular of restraint, but also whether there was asphyxiation in the common understanding, namely some form of either positional asphyxiation or mechanical asphyxiation, whereby there had been pressure applied to Mr. Bio. What we had by this stage, we had the original pathologist who'd given a narrative cause of death, and that's how I termed it. A desire on the part of the Lord Advocate to separate those out, and then instruction of two experts, one of whom had given an opinion that was unexpected, if I can put it like that. And Mr. Anwar was, as I recollect it, keen to put forward experts that he, I would assume, would be able to assist in determining some of the crucial questions. So whilst I know that the number of pathologists is to some extent adding up here, he considered that these pathologists were appropriate and had a particular expertise in relation to determining issues that were considered important.
Did the Crown consider the option of simply going back to Dr. Shearer and Dr. Buhadir, who you've said yesterday were well-regarded pathologists, and simply exploring these additional issues with them if further clarification needed to be sought?
As I say, at the start of this process, of this exercise, my recollection is the Lord Advocate was keen to explore with other experts the various elements, and in particular to seek out experts that could assist in relation to potential exploration, or rather exploration of the behaviour of the police officers with particular reference to asphyxiation.
And in relation to Dr. Lipsage, just to be clear on those three names, he was a consultant psychiatrist, and he was the first and only consultant psychiatrist that was to be considered for instruction.
Yes.
Was he a counterpoint to views on excited delirium expressed by Dr. Karch?
I don't think I would term it a counterpoint, because that I don't think the inquiry should make the assumption that Dr. Karch's opinion was being accepted at all, but rather the consultant psychiatrist was considered of assistance to determining behavioural aspects in relation to the incident and the effect of the consumption of the drugs that were taken.
Thank you. And then I'd like to ask you some further questions. We may be assisted if we look at one of your answers to question 166. Page 102 of your PDF. And this relates to Dr. Karch again, and it relates to comments that he made to the Sun newspaper. here we are. It's on the screen. As I recollect, I was aware of the article referring to Dr. Karch apparently making comments to the Sun newspaper on the day of its publication, and the Lord Advocate was made aware. The Lord Advocate was extremely displeased at the situation and expressed his frustration to Mr. Anwar at a meeting shortly afterwards, and considered that it impacted on the independence and reliability of Dr. Karch. Crown Counsel were aware of the criticism, and I consider it unlikely that Crown Counsel would have placed reliance on the opinion of Dr. Karch. So looking at that, I think we've heard other evidence that, and there's other evidence available to the Chair, that there was a quote in the newspaper from Dr. Karch saying that he saw evidence of heart disease.
Yes.
And making reference to the alleged use of steroids by Mr. Bio. And that was on the 1st of November 2015.
Yes.
So this is after the report's been obtained and concerns have been expressed by the family about Dr. Karch. You've said there the Lord Advocate was extremely displeased by this.
Yes.
And that took the view it impacted on Dr. Karch's independence and reliability. Was there to be any rehabilitation of Dr. Karch after this comment being made to the newspaper?
If I can phrase it like this, the Crown considered that in the light of all of this information, that the opinion of Dr. Karch would be of limited assistance in reaching the conclusions that it required to reach.
And you say limited assistance. So what would that limited assistance have amounted to?
Less than de minimis.
Thank you. Is it fair to say that the Lord Advocate no longer wished to rely on the reports or views of Dr. Karch?
Yes, I think that he made that clear, and that was made clear in the presence of Mr. Anwar.
So from around the 1st of November, or within a short period after that, the Lord Advocate made his views clear. And presumably if the Lord Advocate, the head of Crown Office, says we don't want to rely on the report of Dr. Karch, is that taken seriously in Crown Office?
Yes.
What steps did you take to ensure that no reliance would be placed on the report of Dr. Karch?
Well, there was a widespread awareness of the views of the Lord Advocate in respect of Dr. Karch.
And is that widespread in your team as well?
I think in relation to, yes, I consider that there was within that, and yes, I do.
And we will hear we will discuss in due course the fact that Alistair MacLeod wasn't part of your team in November 2015. There's a question mark about when Erin Campbell came on board. And as I understand it, Ashley Edwards had not been become the dedicated advocate deputy at that stage.
Yes.
To what extent did you take steps to ensure that anyone coming onto the team to help with the investigation would know in the future that views had been expressed by the Lord Advocate about Dr. Karch?
Sorry, I can't recollect anything specific in relation to that.
Did you put any warning on the report in the file, or a notice on the front of the file, or some sort of rider attached to any of the correspondence?
No.
Did you assume that anyone becoming involved in the investigation would know about the issues with Dr. Karch?
At the time, everybody was aware of the situation with Dr. Karch.
You've said there Crown Counsel were aware of the criticism, and I consider it unlikely that Crown Counsel would have placed reliance on the opinion of Dr. Karch. As I understood it, Crown Counsel, Ashley Edwards, who became the dedicated Advocate Depute in the investigation, had not been appointed to that role in this period, round about November 2015. How were you satisfied that she was aware, or became aware at the point she was involved in the investigation, became aware of the criticism in regard to Dr. Karch?
I'm sorry, I don't have a recollection in relation to that.
Did you take any steps to draw this to her attention when she did become involved?
I don't recollect any, and maybe that was an assumption on my part.
There's evidence available to the chair that Miss Edwards was not aware of any issues relating to Dr. Karch, or if she was, she doesn't now recall. She's not aware of either of the relevant Lord Advocates held views with regard to Dr. Karch. The only information she used to assist her understanding of Dr. Karch's opinion was the opinions of the other experts in the investigation. So it would appear that she did not know about these concerns, did not know about the concerns expressed by the Lord Advocate and the view taken by the Lord Advocate, and had read the opinion of Dr. Karch. Does that cause you some concern looking now with hindsight?
I don't know that, well, I think there's a number of considerations there. It's obviously regrettable if there wasn't widespread awareness of that, because it was more than widely known within the investigative team. With regard to the opinion of Dr. Karch, I'm confident that during the course of the inquiry, the views of Dr. Karch were entirely at odds with every other expert who expressed an opinion. And that in particular, although I know Dr. Karch made reference to excited delirium, he also made references, I think you mentioned there very clearly, to apparent heart disease, and that he noted evidence of heart disease, and that subsequent experts who had a specific expertise in respect of that indicated that there was no evidence of that whatsoever. And indeed, my recollection is that not only they confirmed that, but the original pathologist confirmed that. So we had a situation whereby Dr. Karch was expressing an opinion that it was entirely at odds with every other opinion that had been expressed. So to that extent, I consider that is partly why I expressed in my view that I think it highly unlikely that Crown Counsel would have placed any reliance on the evidence of the opinion of Dr. Karch.
Can you think of a way in the future to draw attention to members of Crown Office staff to specific concerns being raised by the Lord Advocate about individual experts or other matters? Is there a mechanism whereby that a warning could be retained on the file, or something could be used to draw that to their attention?
I could give that some consideration. The situation is that once, to some extent, once a report is brought into existence, it's in existence. Although the Lord Advocate was expressing extreme frustration, that was in the moment, because I think that he was expressing frustration on the time at the time that the specific newspaper article had appeared. So there was frustration was perhaps an understatement as to how he felt in relation to this. But depending on further procedure, there would be disclosure issues in respect of a report that had been obtained. So to some extent that would have to be factored, I think, into anything. But clearly, in respect of comment by the Lord Advocate as regards what his wishes were at that time, in respect of the instruction of a report, there could be some form of recording that would have made that clear.
All right, I'm conscious of the time at the moment.
We'll take a 15-minute break. Graham.
Thank you.
I wonder if there's something that I could just add in respect of the questioning just before we broke.
Of course.
The questions were, you were asking me about the impact of Professor Karcher on Crown Council's decision making and reflecting the fact that there is evidence before the inquiry that some of the team, including Crown Council, weren't aware of the Lord Advocate's views. I think I did allude to this yesterday, but in respect of the impact that Professor Karcher, Dr. Karcher's opinion could have had, as I said yesterday, for the purposes of the decision making at each point, Crown Council made the assumption that the causal link was established. So to that extent, it couldn't have had any impact on Crown Council's decision making.
Certainly not in relation to the cause of death. Leave it that as that. We're talking about period 2, the year between August 2015 and August 2016.
Yes.
And during this particular year, I think the inquiry is aware that a further 6 experts were formally instructed between the 13th of November 2015 and then the final report, I think, was obtained in May of 2016. So during that period, experts were being instructed and producing their reports. And they were Dr. Lipsage, who we've heard was a psychiatrist.
Yes.
Professor Mary Shepherd, who you actually mentioned just before the break, who we've heard was a cardiovascular pathologist. Dr. John Parks, a psychologist. Dr. Anthony Bleekman, a doctor in emergency medicine. Dr. Elizabeth Solyu, I'm sure I've pronounced that incorrectly.
That is the correct pronunciation.
Oh, is it? Thank you. And she was a histopathologist who was looking into issues regarding sickle cell anemia.
Not at that stage.
Right.
My recollection is that both Dr. Shepherd and Dr. Solyu were instructed in respect of the heart, whether there was any underlying issue with the heart and the effect of drugs in the heart, and in particular the comment by Dr. Payne James in his report that the expert opinion of in relation to that, and a cardiac specialist or specialists should be sought. That, to my recollection, was the reasoning behind the instruction of Dr. Mary Shepherd and Elizabeth Swallow.
I apologise. So it wasn't until a later stage that Dr. Solyu then started to look at sickle cell.
Yes.
Thank you. And then finally, the 6th expert was Professor Jack Crane, who we mentioned before the break, and he was a forensic pathologist also.
Yes.
Thinking about that period between August 15 and August 16, when the final report was prepared, can you tell us, in your experience, not prior to the investigation of Mr. Bile, but just generally your experience as head of Cat D, was that period of a further year, having obtained the first PERC report until obtaining the final PERC report, how common was it for a further year to elapse before the final PERC report was available?
If I can put it this way, and in thinking back, I don't recollect any other case where there was a period of that length.
And we've heard some evidence from PERC witnesses, and again I'm summarising here, that the reason for that period of an additional year until the final PERC report was sent in was because of the extensive additional instructions that had been sent to PERC by the Crown, starting with your letter of the 2nd of September 2015, and that caused that delay before the final report was prepared. And I wonder if you have any comments on that.
I think it's important to bear in mind that there were other aspects of this investigation that PERC were asked to investigate. There was obviously investigations in relation to data protection from a variety of aspects. There were instructions to investigate material that was held by Police Scotland. There was the instruction, obviously, to investigate the sending of texts, and in particular whether there was a connection in relation to the sending of those texts. There was consideration of whether there had been an attempt to pervert the course of justice. All of those, to my recollection, were aspects of the investigation, as well as the core incident on the 3rd of May. So to that extent, there were various elements to the investigation. That's the only comment I would make in respect of it.
So in terms of that period, did you have any concerns about the additional 1 year period being required for PERC to complete that investigation?
Obviously, one would hope to get the report as quickly as possible, but that's the only comment I would make in respect of that.
Were you satisfied that you did get the final report as quickly as possible?
I think that's quite a difficult question for me to answer. Obviously, we got it when it was submitted, when it was approved for submission, because I think there is a checking process that goes on in PERC. But I don't recollect any particular representations being made by PERC in respect of them, considering that there would be a significant delay.
Right. And did you consider that this was a delay which caused concern to the Crown?
Well, as I say, I am mindful of the fact that it caused concern because of the impact that it probably would have on others, in particular the family of Sheku Bayo, and the clear interest that they would have in this progressing as expeditiously as possible.
And we looked at the Crown relationship with the family and engagement with the family in the earlier period.
Yes.
During this period, I think the inquiry has information available that there were 4 meetings in Crown Office, 26th of August 2015, 8th October 2015 and 5th November 2015. And then a further one in 2016, 9th of May 2016. Frank Mulholland was the Lord Advocate during that entire period. James Wolfe didn't become Lord Advocate until later. Did this period of 1 year while you waited for the final PERC report have an impact on the Crown relationship with the family?
Again, I can only give my own impression.
Yes.
In respect of that. I think there was every attempt to keep the family advised as to what was happening in general terms, even although the investigation was with the PERC, that the intention was to reassure them that it remained a priority, in the sense that the law officers and the core team were pursuing the case, and that it was still something that was high on the agenda, if I can put it that way.
All right. And could there any more have been done by the Crown in the interest of minimising any delays or the duration of the investigation? Was there anything more that could have been done by the Crown to keep that period as short as possible, perhaps shorter than it was? Looking back now.
I'm afraid there's nothing springs to mind at the moment.
All right. I'd like to move on to, again, focusing on the race investigation and Article 14, again in relation to this period of around 1 year. By this stage, the Crown have raised the issue of race specifically, because after the first report from the PERC, your letter of the 2nd of September specifically raised that issue
Yes.
with them. And you've given evidence earlier today that the Lord Advocate was clear that considerations of race would have to be a focus, and race was central to the investigation. We have heard evidence from PERC under reference to the log, the decision log that we've looked at a couple of times today, and evidence in regard to this by the lead investigator, Mr. McSporran. And again, to summarise that evidence that we've heard, it would appear that PERC were investigating racism in Fife, in particular in relation to individual officers, text messages, and whether there'd been contact with the attending officers. PERC were investigating the Professional Standards Department records of officers who were involved in the incident, looking for areas where allegations of racism, discrimination, discriminatory behaviour appeared. And they were also examining the history of PC Payton, one of the individual officers who attended. It would appear, and this will be a matter for submission for the chair, but it would appear that perhaps PERC did not go much beyond the specific instructions that the Crown had given to PERC.
Yes.
Now, you've explained earlier today that you made a general comment and you raised it generally, and you would have had expectations on PERC that they would, can I use the phrase, pick that up and then pursue lines of investigation that they saw appropriate. But it does appear that they stuck to within your specific instructions, which came, I think we
Yes.
looked at from the concerns of the family.
Yes, and I know I've referred to concerns with the family, but there was an expectation that the PERC were engaging with the family actively and were in a position to respond in particular to the concerns that they had in relation to race. But yes.
Right. I think earlier in your evidence you said there had been a breakdown in the relationship between the family and PERC by this stage.
We were advised that, yes.
You were advised of that. So you knew that that relationship had broken down?
Well, we'd been advised, I think by Mr. Anwar, that the relationship had broken down. I mean, relationships can fluctuate. I mean, you can take steps to repair a relationship or to build one up again. So I know that's a generality, but I wasn't proceeding, and I don't think the team were proceeding in the instruction that it could not be repaired. And certainly, as I recollect, I don't think I'm wrong in relation to this. At the time that letter was sent on the 2nd of September, that was sent, I think, deliberately at that time as quickly as possible, because a meeting with the PERC and the family was due to take place within the next few days. I hope I'm not wrong about that, but I seem to recollect correspondence that indicated that that was about to happen. So that was an opportunity to perhaps reset, because there had been correspondence, there had been an instruction and detailed instructions from the Lord Advocate at that stage. And Mr. Anwar knew that there had been that meeting and that further instruction, because I recollect that there was correspondence that was sent to him to advise him of that. And that correspondence, I'm pretty sure, included reference to the reminder about race.
I'd like to ask you if you accept from me for the moment that perhaps the scope of the PERC investigation during this period in relation to race was very much in line with the
Yes.
the Crown instructions.
Yes.
And there was no real line of investigation developed or pursued by PERC that went beyond the four walls of the Crown instructions. Were you aware of that the PERC approach was limited to the Crown instruction?
No. And I do make reference to some discussions that took place and some further correspondence that I'm sure you're aware of that did make further reference to race.
Had you known that the PERC investigation would be so restricted to the Crown investigation, the Crown letter of instruction, would that have caused you concern during that year period that we're looking at?
I think one of my concerns subsequent to the sending of that letter was that the considerations of race had to consider the actions of the officers at the scene and what their what aspects of their behaviour was relevant to that line of inquiry, whether it had any influence of race, irrespective of, and the term was overt racism, whether any other factor linked to race had affected their overall approach to dealing with Sheku Bayo.
Do you feel that you communicated that desire to PERC in correspondence or in communications?
Well, I did make reference to the distinction between overt racism and what I termed in my statement implicit bias, in the sense of had attitudes or beliefs or perceptions been influenced by race. I do recollect, because it's certainly in the correspondence, that there was reference to the perception that this might be a terrorist incident, and I well appreciate how offensive that will appear to the family. But there was reference to that. From my perspective, that was something that was clear and obvious and had a link to the inquiry.
So that wasn't in the 2nd of September letter, but that was in subsequent correspondence during this period.
It was in correspondence, and it was in a conversation, or rather a discussion, about which there was a note, a file note that I've referred to in my statement.
Right. We'll come to your statement in a moment. Let's look, as well as those instructions that had been given, you'd also instructed PERC to undertake an audit of Police Scotland's IT systems that were operational and determine if an officer had unlawfully accessed the data of certain persons that were named in a letter or letters sent by Mr. Amar Anwar. We've heard evidence about that. As part of that instruction to look at the actions of the officers, did you consider instructing PERC to consider whether there were any unlawfully accessed data searches and to consider the racial implications of any searches?
I don't recollect any specific instruction in respect of that.
When looking back now, do you think that would have been an appropriate instruction for the Crown to give PERC to consider the racial implications of those searches?
I think that would have been a consideration depending on the results of the actual examination as to whether, first of all, there had been any access, and secondly, what the reasoning had been for that.
And we've heard evidence that there were searches carried out in relation to Mr. Anwar himself, and there was a classification of data that had been recovered. In light of that, when you became aware of that, did you consider instructing PERC to carry out some sort of analysis or assessment of the racial implications of any of that information?
I think in respect of that particular aspect, the focus of the Crown concerns, and they were very clear concerns on the part of the whole of the Crown, including law officers, that the focus of that should be to ascertain the basis upon which that information was held, and whether there was anything more to be seen in the light of the way that information had apparently been recorded. And I think I've referred to in my statement that PERC were instructed to explore that, but that shortly after that a decision was taken, which I was aware of by others at the Crown Office, that the most appropriate way to pursue these and the most effective way to pursue these was through the Office of the Information Commissioner. And that was an ongoing investigation.
But in relation to the obligations on Crown Office in relation to Article 14, and not just on Crown Office but on PERC, was there consideration given to exploring the racial implications of this information, not just from the point of view of whether there was or was not criminality, but whether there were any racial implications in terms of Article 14?
As I say, there wasn't a specific instruction. I don't recollect that particular consideration was something that was put forward at that time. But depending on the results of that, then it's entirely possible that would then become a focus of the subsequent investigation. But at that stage, it was focused on finding out what the situation, what the factual position was.
So in fact, no Article 14 issues were pursued in relation to that matter at that time?
I don't recollect there being that being a focus.
Right. And in relation, we've talked briefly about excited delirium and its appearance in the opinions of Dr. Karch and Dr. Payne-James. We've talked about the concerns of the family, particularly in relation to Dr. Karch, I think you said. Was there any instruction given or consideration given to considering the racial implications of excited delirium as part of your Article 14 investigation?
No, I don't recollect any. This would be some form of consideration as to excited delirium in relation to a link in racial
Yes.
cases.
We've heard some evidence, and primarily from Dr. Lipsitch, to the inquiry, that in fact there are racial roots and implications in relation to that, and the way it has traditionally been used as a cause of death in relation to black men who have died at the hands of the police, and that is used as a mechanism whereby the use of force and the consequences of use of force in the cause of death are minimised in favour of pursuing a line of excited delirium and a narrative that presents that as the cause of death. I think that's my summary of evidence that we've heard.
That was not something that neither I nor anybody else was aware of, and to that extent there wasn't any exploration of that aspect.
So in terms of the obligations on the Crown under Article 14, in conjunction with Article 2, what steps were the Crown taking during this period of a year between the two reports to comply with obligations under Article 14?
I think the position of the Crown was that it was attempting to provide further instruction to the PERC and the various elements that PERC were being directed to investigate, including race, and that the report that PERC would ultimately produce would be assessed in the light of all of the instructions that had been given. But in effect, the investigation, I suppose, was back with PERC at that stage.
So in a sense, when you say back with PERC, were the responsibilities and actions in relation to Article 14, were they being carried out more by PERC at that time?
Well, I think the obligations in respect of the investigation had substantially transferred back to PERC in the light of the fact that they were in effect going to produce what became their final report, but their second report.
And in terms of your perspective, did that alleviate's probably maybe not the right word, but did that release the Crown from their obligations under Article 14 because they had handed over that baton to PERC?
I think the position would be that the Crown has got that obligation, that it doesn't shift back and forward. I think both organisations have got the obligation. But looking to the practicalities of the situation where PERC had been instructed to carry out significant further inquiries, and to get back to the point, I don't recollect any indication as to how long it was anticipated that those would take, but in effect they took a year. That was the direction that I was aware personally. Whether there was other consideration going on elsewhere in the organisation, I don't know. But that was what was happening at that stage.
So in terms of the Crown's obligations, in terms of Article 14 in conjunction with Article 2, the way in which the Crown was endeavouring to comply with those obligations was demonstrated by the instructions to PERC that were being given during that period.
Yes, the overall investigation that at that stage that was being actively pursued by the PERC with the intention of submitting a full report to the Crown as quickly as possible.
And if there were any others in Crown Office taking additional steps to comply with Article 14, Article 2, would you have anticipated that they would have informed you of any other additional steps because you had oversight of the whole investigation?
Yes, I think that would be the case. If there was anything that was affecting the investigation, the chances are I would know about it. Although, as I said just a second ago, in relation to the inquiries with the Information Commissioner's office, that was something that I was not directly engaged in. That was taken at a pretty senior level at Crown Office, and there were some meetings, I'm confident, that took place with the Commissioner where I was not present, and that certainly was one of them, because I know that the Commissioner was present at that meeting.
Can I leave aside the Information Commissioner aspect for a moment?
Yes.
But did any others in Crown Office come to you during that period and say, we are also doing X, Y, and Z, whatever it may be, you might want to know about this because this is in furtherance of Article 14 or Article 2? Did anyone come along and say anything like that during that year?
Not that I recollect.
Looking at the Information Commissioner element, and this is the audit being undertaken, or PERC were instructed to undertake an audit. We've heard that ultimately was done by Police Scotland. Were you aware that Police Scotland carried out the audit? We've heard for security reasons.
Sorry, I think what audit is it you're referring to?
Your instruction to PERC in relation to the database searches. you asked PERC to conduct, the word that was used in evidence was audit,
Yes.
to assess those database searches. That was a concern that was expressed by Amar Anwar
With the list of
with
names.
the list of names.
Yes.
And you then instructed PERC to do an audit of that.
Yes. That
And-
wasn't, I'm sorry.
Sorry, no.
That wasn't so much the Information Commissioner's Office concerned. That was something separate.
Yes.
But in relation to the audit, in relation to the access, whether there was evidence of unauthorised access to the list of names that Mr. Anwar provided, your question is, was I aware that Police Scotland carried those out? I don't recollect that I was.
Would that have been of concern to you in relation to thinking about the comments we discussed yesterday about the importance of independence to an Article 2 investigation?
Yes, it would be for the same reasons as I tried to articulate yesterday. The focus on independence and the perception of independence are of crucial importance. And thinking out loud in respect of that, the consequence of that, how could PERC assure themselves that the check had been carried out accurately?
And having commenced this investigation as part of the Crown instruction, one of the names on the list was Mr. Anwar.
Yes.
And that then led on to the situation with the Information Commissioner, as I understand
Yes.
it. And I think earlier when I was asking about this, you said there was, and forgive me if I'm misrepresenting, I don't have access to the transcript at the moment, that there was not any aspect of that part of the PERC investigation where you asked them to consider racial implications or Article 14 implications in relation to the Amar Anwar intelligence.
No.
So, in fact, in terms of an Article 14 compliant investigation, this aspect of the PERC investigation had nothing to do with Article 14 in terms of no instructions from the Crown to investigate the racial implications, whatever they may be.
And we're talking about the
Intel with Mr. Amar
Mr.
Anwar
Anwar,
and the data searches and that aspect.
yes, I'm clear.
So you agree that that wasn't part of any Article 14?
There wasn't consideration at that stage. The focus, as I said, was on trying to establish the factual position in respect of that.
And so as the PERC investigation is carried out during this 1 year period to complete their final report, I wonder if we can go back to look at paragraph 102 of your inquiry statement. I stopped you earlier at the point where you said you were moving on in terms of chronology, so I'm looking at paragraph 102, and we had looked at the early parts of that, and this spans a number of pages, you'll recall. So it's 102. As I say, it does cover a number of pages here. There we are. And you'll recollect that the issue of race was central to the ongoing investigation. And we looked at that earlier. And if we can move down, you were talking about PERC provided assurance prior to the submission of the first report that if racial motivation was identified in the course of the investigation, this would immediately be referred to the Lord Advocate, and race was clearly within the scope of their considerations during the first part of their investigations. And then following my meeting with Inquest and the interaction with the family, following submission of the first PERC report, I submitted a full analysis in a briefing to the Lord Advocate and referred to the Sean Rigg investigation. So this is the point within paragraph 102 of your statement where you start to talk about a period after you've received the first PERC report and before the final report has been received. So let's look through this paragraph, please. You say, it also identified areas of further inquiry that required to be undertaken by PERC before a decision could be taken on whether there was evidence of criminality. And is that a reference really to your 2nd of September letter that we've looked at in some detail?
Yes.
The issue of race was specifically highlighted in my letter of further instruction to PERC, asking for confirmation that race and whether there was evidence of racial motivation was a primary focus of their investigation. And then you say, my recollection is that at the meeting attended by Stephen McGowan and myself at PERC in October 2015, that is referred to in the file note, there was discussion regarding the approach to racial matters. And is this the meeting that you mentioned shortly a moment ago?
Yes.
Where there was a meeting with PERC about racial matters between you and Stephen McGowan in the October, the month after your letter?
Yes.
My intention was to make clear that whilst evidence of overt racial motivation was to be investigated, that there required to be consideration by PERC of implicit bias in the sense of whether the approach of officers was in any way, including in an unconscious way, influenced by race.
Yes.
And do you feel that you were able to communicate that effectively to PERC at that meeting? That was your desire from the perspective of the Crown?
Yes.
That this investigation by PERC would not just be simply in relation to overt or obvious matters, but would look beneath the surface and actually consider things such as implicit bias.
Yes.
And was there discussion about how that would be achieved at that meeting?
I don't recollect specifically any discussion in relation to that.
Were you asked any questions by PERC at that meeting about how they would go about investigating implicit bias?
I'm sorry, I have reflected because coming to give evidence, and I don't recollect the detail beyond what's contained within the file note. But what I do recollect was that I took the decision to raise this at that meeting in order to make the point that it did require to focus on the incident and that evidence of overt racism was not an end of racial consideration.
From your recollection, did Stephen McGowan provide any further guidance to PERC in relation to how he saw the investigation?
No, I don't.
Were any examples given to PERC about things that could be considered?
I can't clearly recollect whether there was. I know that my later correspondence did refer to the perception of terrorist threats, so it's entirely possible that I highlighted that. And the reason I mention that here today is that, to me, that was the clearest factual example of the type of thing that I was talking about.
Was there discussion about analysing the language and comments made within the statements of the officers on the 4th of June?
No, I don't think there was.
Had you had an opportunity to read those statements by the date of that meeting?
I can't recollect if at the date of that meeting I had.
Were there any other examples given about lines of inquiry that could perhaps have been pursued in relation to issues of race and racial motivation, particularly regarding the events at Hayfield Road, or trying to determine if there was any type of racial motivation on the part of the officers?
I don't recollect any detailed questioning or discussion in respect of this. But as I say, my thinking at that time was that there required to be that analysis of the situation provided, and I did it.
Was there any discussion about how inferences could perhaps be drawn? Inferences about race or racial motivation?
No, I don't recollect anything in relation to that.
Was there any consideration to the speed at which events occurred and the speed at which officers elected to use force in the circumstances, and whether that could give rise to any inferences of racial motivation?
No, I don't recollect any that it being put in that way.
Was there ever any consideration or discussion at that meeting about whether PERC should go back to the police officers and seek further statements?
I don't think there was any discussion in respect of that, but that was a course of action that with hindsight, I think was open to PERC and may well have been appropriate.
We've heard that there were no race questions in the witness interview strategy, and although matters impacting on race may have appeared in the statements, there was no particular probing in those 4th of June statements. So was it ever considered that might be a useful line of investigation?
With hindsight, it would be a useful investigation, but I don't recollect any detailed discussion in respect of that.
Would there have been anything stopping PERC going back to the officers and asking if they would give a further statement, specifically about race and racial motivation?
No, I don't, having regard to the stage that the investigation had reached, because it was PERC already had the whole investigation, or rather the further work to be carried out, and the expectation was that they would be in a position to progress that, and I don't think there was anything to stop them making inquiry of officers as regards what their state of mind and their rationale, and in particular, I suppose, in relation to the terrorist threat, as to why they made that connection, what were the factors they took into account, and I suppose the obvious question, although I don't recollect this being articulated at the time, where you would say, well, would you think that all the time, or what was it about this incident that made you make that connection?
Perhaps considering whether a comparator, a hypothetical comparator, what approach may they have taken if Mr. Bio had been white? Was there any discussion about using a white man as a comparator?
Yes.
Yeah. There was discussion about
No,
that.
I'm sorry. I accept that would be one way of approaching it, but there wasn't any discussion about that.
Was there any discussion about whether less forceful options would have been open to the officers and were precluded, and whether that could be probed and considered?
I don't recollect any discussion in respect of that.
Can we move down, please? That clarification was also provided in my letter of the 13th of January 2016. So that's around 3 months later. The meeting's in October, this letter's in January, and this is to John Mitchell, Director of Operations, that referred to earlier discussions and sought to draw the same distinction between overt racism and the overall approach to the incident, including whether they considered that the incident was potentially terror-related. And so is this the point at which you specifically raised that connection with the terror-related matter?
Yes. So I was referring to the distinction between overt racism and the overall approach to the incident, including as one example, whether they considered the incident was terror related. So that was one example of their overall approach to the incident.
And this is January 2016.
Yes, it would be.
I was reassured by the reply from PERC that stated, for the avoidance of doubt, that their report would, where possible, address the issue of whether there is an indication that race influenced the approach taken by officers, either individually or collectively, in the response to the incident.
Yes.
And that reassurance was given to you in 2016?
Yes, it was. And I think I am quoting directly from the terms of that letter, and there was no indication that there was difficulties being experienced, or how do we do this, or it was an assurance. I was reassured by the reply. It said, for the avoidance of doubt. That was I think that was the terminology used.
So there was an emphasis, in a sense, put on that.
Yes.
And then can we move on, please? My advice was given against a background where it was accepted that at all times race and racial motivation required to be considered as a continuous process as the inquiry progressed, and that an absence of overt racial motivation should not be regarded as determinative. Consideration of implicit bias and assumptions based on race in the overall approach required to be assessed as the investigation developed and the evidence was gathered. So is it your understanding that where there is an investigation, and if it is to be compliant with Article 14, that race and racial motivation should be considered as a continuous process as the inquiry progressed?
Yes.
From beginning to end?
From beginning, yes.
And moving on, please. The team at Crown Office would have been aware that PERC had been specifically directed to investigate allegations of past racist behaviour by officers. These investigations were instructed to provide potential context and background to the behaviour of officers during the incident, and were not confined to whether a separate crime could be proved. I'm interested in this sentence. So when you say the team at Crown Office would have been aware, was this in 2016, or generally your team would have been aware?
I think I meant generally.
Generally. And was this so broader than just simply 2016? Were your team aware when the investigation into the death of Mr. Bio was going on? Because that obviously took place over a number of years. Were your whole team aware that it was these investigations regarding racist behaviour provided context and background which was relevant to the behaviour of the officers at the time in Hayfield Road?
Potentially relevant. It was a consideration, yes.
But that could provide some sort of context, some sort of background to the actions taken by the officers at Hayfield Road?
Potentially.
Potentially. And it wasn't simply confined to whether a crime could be proved?
Yes.
The team were also aware that Addie Johnson had raised the issue of an investigation into alleged racist behaviour by Fife officers, but PERC had been unable to identify the incident until I became aware that Fife officers had sent racist texts when another separate and unconnected case was brought to my attention that referred to such events. This resulted in an instruction to PERC, sorry I took my eye off the screen there, this resulted in an instruction to PERC to investigate whether there was a link to any officers involved in the incident on the 3rd of May 2015, and the Crown Office team were cited on this and analysed the results in the precognition. So is this at a stage where you're actually in the process of carrying out the Crown precognition after the final PERC report had been received?
at that stage when there's reference to the precognition. But in relation to that inquiry, that was at a much earlier stage. And in fact, my recollection is that very, very soon after the events in May 2015, that there was information, and as I recollect it, quite specific information coming from Addy Johnson through Mr. Anwar, but also I think directly through Addy Johnson himself, that he recollected being involved himself in some form of investigation that involved officers from Fife Constabulary, that it had a racial element, and as I recollect it, he was being brought in to assist the police in respect of that. So there was information, and that was communicated, as I recollect, to the PERC. And the PERC had advised, I think repeatedly, that they were unable to locate anything that bore any resemblance to that. That's my recollection in relation to this. But as I said in my statement, while I was working one day, there was an entirely separate inquiry that had come from, I think, a High Court case where there had been an inquiry, I think, about the whereabouts of an officer, or an officer who had been dismissed. And that was the focus of that's why it came to my attention. It was in relation to what we knew about this officer, whom I think was a potential witness in an entirely unconnected High Court case. And I'd asked about what it was, or information had been given to me that it concerned an allegation of racism, and he was no longer a police officer. And I'd asked, well, where was that? And then it became apparent that it was in Fife. And I provided the name of that officer, obviously, to PERC, and I immediately advised the Lord Advocate, and I think, again, it was a meeting with the Lord Advocate, that I was able to say, well, we've found what it was that, or apparently what it was that was being talked about.
So it was thanks to you that connection was made?
Well, it was by chance, and I said it was by chance, but I certainly made the link, which it had been brought to me entirely by chance. And I did say in my statement that I thought that did demonstrate the value of actively engaging with the family, because I know that Addy Johnson was very clear. It wasn't just something that he'd heard, he'd been involved in this. And to that extent, I was able to give the name of the investigation to allow the PERC investigation to progress. But prior to that, I think that the correspondence will demonstrate that despite the provision of that information, that there was an apparent
We've heard there was
inability.
No connection.
We've heard there was no connection, yes.
I'm interested in the fact that you say PERC couldn't find anything, because you've talked in your statement about your view about them being very highly skilled and experienced investigators. Did it surprise you that they couldn't find anything?
Yes.
Did it cause you any concern?
I think my position was that I found it surprising that with the amount of information that had been conveyed, that I think was reasonably specific, that inquiries had not been able to identify that. It had, from my recollection, it had resulted in disciplinary proceedings and dismissal, and that was something that I found puzzling.
I'm conscious of the time now. I wonder if that might be...
We'll stop there and continue with your evidence at 10 o'clock tomorrow morning, Mr. Brown.
Well,